Well, good morning, everybody, and welcome to the first VTIC webinar of 2018. Proudly brought to you by VTIC, the Victoria Tourism Industry Council, and of course our partners, web firm, VTIC's digital marketing partner. And once again, thank you, Reese Kerr, Business Manager Extraordinaire at web firm, for all your help. Guys, we've got a really exciting program ahead. As you've seen from our events calendar, some great webinars planned not only for today, but also for the coming couple of months. I'll talk on those a little bit later on. But today's webinar is all about workplace relations. And I'm really delighted to introduce Richard Williams, who's the Acting General Manager, Workplace Relations at the Victorian Chamber of Commerce and Industry. And as you can see on the screen, VTIC works with a number of different organisations, ATAP, ATEC, BEV, the Melbourne Chamber of Commerce, but of course our major partner is the Victorian Chamber of Commerce and Industry, the peak employer body in the state. Now today's session is all about workplace relations, everything everything you needed to know, wanted to be aware of, and even more. And Richard has a wealth of experience about that. As I said, he's the Principal Workplace Relations Consultant and Acting General Manager Workplace Relations, which I've had since for the last couple of years now. Over 12 years experience in senior human resource management and workplace relations. So anything you need to know, now is the time to ask your questions, now and for the next hour or so as Richard goes through his presentation. Richard has worked in a load of fields, the higher education, manufacturing and local government sectors, and has managed a wide range of industrial and employment-related matters at the workplace level and before external tribunals. He is known for his and I'm reading this out, his very level-headed and outcome-focused approach to complex employment issues. I can really think of no better person to talk to us today and to kick off VTIC's 2018 webinar schedule than Richard. So Richard, the floor is yours.
Thanks very much, Ian, and thanks for participating in this webinar. Just at the outset, I'll explain that as a disclaimer that what we're about to go through today can't be construed as legal advice. We're consultants rather than lawyers, so please don't take what we're about to learn as legal advice as such. In preparing for this presentation, what we've tried to do here is to select some key aspects of the Workplace Relations Act and talk about those, or the Fair Work Act, and talk about those, and to link case examples that are going to be relevant to all businesses regardless of size and sector. And the particular theme today is the trend that we see around the discretion that the Fair Work Commission has, in particular in relation to unfair dismissal applications, and the lessons that we can all learn from those trends. So as an overview, I wish to touch upon the stop bullying legislation. I then wish to talk about some quite significant developments in the use of fixed term contracts and a major decision that came through at the end of last year that impacts upon any employer that uses fixed term contracts as a mode of employment. Then the main focus will be on the unfair dismissal legislation, and in particular the discretion that the Commission has when it takes into account any other relevant matters. We've got 3 or 4 case examples there which should help explain some of the lessons that employers can take from those cases, and just wish to conclude as a natural link into some important lessons that can be learned with respect to how to conduct workplace investigations and when a workplace investigation may be an appropriate method to look into a grievance or a complaint or a conduct issue.
Wow, this is going to be a really interesting webinar, Richard, so thank you for that. And again, just a reminder to everyone, questions, we can ask them as we go. We don't have to wait until the end to ask questions. So any you have as Richard goes through, please just jump in and we'll try and get to them.
Thanks, Ian. Well, to start with, it's worth having a look at the stop bullying legislation and the power that the Commission has. This is a relatively new provision in the Fair Work Act, and we expected to see a flood of stop bullying applications arise once this legislation was made, and it was rather slow to take off. But what we're seeing here at the Victorian Chamber, more and more applications that are coming through the Commission, and as a consequence, we've been able to learn a little bit more about how the Commission will approach an application from an employee to a stop bullying order. Now, the stop bullying legislation is quite specific. For a behaviour or conduct to be considered to be bullying, it must be repeated, and when we say repeated, it literally means more than once, and it must be a behaviour that creates a risk to health and safety. So if the Commission is considering whether or not bullying has occurred, it will need to look at whether it happened more than once and whether it actually creates a risk to health and safety to that person. The key message that we want to get across here today is that reasonable management action carried out in a reasonable manner does not amount to bullying conduct at work, and that's a very important concept to try and understand, this concept of reasonable management action.
Yeah, just a quick one there, Richard. Pete, who's a regular at our webinar, it's good to see you here again, Pete, has asked a quick one about the health and safety question. Are you talking about just physical health or also mental health?
Oh no, certainly mental health and safety as well, or mental well-being as well, not just physical health and safety.
Hope that clarifies, Pete.
And actually, to take that a little bit further with the bullying application, it would most likely be a risk to someone's mental health and safety rather than physical health and safety.
Ah, gotcha. Thank you.
The key message here is this concept of reasonable management action. And as a bit of a Dorothy Dixer, the question always comes about, well, what is reasonable management action? And in typical employment law terms, it is what a reasonable person would consider to be a reasonable action, which is not particularly helpful. But the important message is that what an employee perceives as reasonable or unreasonable action isn't the test. It's the Commission that will make that test. In other words, what we see more and more is that stop bullying applications are made as a consequence to a performance management process. Just about everyone that we see that comes across our desks is in direct response to a performance management process. And if a performance management process is carried out in a reasonable manner and the reasons for that process are reasonable as well, then the Commission will find that it's not bullying but reasonable management action. By way of example, we've got a case here which is a New South Wales case involving a bowling club up on the far north coast of New South Wales, and this case is relevant because it did actually look at the definition or concept of reasonable management action. The employee in question here, a female employee, alleged bullying on 4 different counts. And the first one went to a complaint that she received for an inappropriate interaction with staff members that occurred about 12 months before she received the warning. The second allegation was bullying on the grounds that she received an oral warning as a consequence of an interaction that she had with a bar staff coordinator. The third allegation that she put was a failure of the organisation to conduct a fair investigation into a complaint that was made against her. And the fourth allegation that she made was that she was bullied on the basic grounds that she'd made a complaint.
Yeah, that's great. Thank you, Rich. Actually, we've got another question's come in, this time from Darren. Thanks, Darren. And Darren's actually asked a really good one about turning the tables and asked, is there a specific best practice for when a junior team member that is harassing a senior team member? The policy to protect the workers, but what about the management if the tables are turned, Richard?
I'll provide practical advice here rather than from past experience in human resources roles. And the manager in this situation has the opportunity to make a complaint against the person who is reporting to him or her. But in practical terms, I think it would be very rare for a manager to make a complaint as such against an employee. I think in this example, this is exactly the case of where the manager would take reasonable action to address the concerns that he or she had with the employee, that this is a conduct issue. And it's an awkward one, but I think that the manager needs assistance in managing that situation rather than treating that as a complaint or a grievance.
Cool, great, thank you. I hope that helps, Darren.
So there were four allegations of bullying, and the Commission was obliged to have a look at those four allegations and determine whether or not they did actually constitute bullying. And in doing that, the Commission adopted this concept of reasonable management action. The Commission found that the investigation into the complaint against the employee was fair and that was reasonable. The Commission found that it was reasonable that she received an oral warning for the interaction that she had with the bar staff coordinator. But what the Commission did find was that one allegation was actually substantiated, and that was the allegation about the unfairness of the warning that she received. And the background here is that there was an investigation into a complaint made by a former staff member, and during that investigation process it was found that she did in fact behave in an inappropriate manner some 12 months earlier, and the bowling club put in place a warning saying that there needed to be an immediate improvement, that any further instances would result in serious disciplinary action, including termination of employment. And the Commission found that it was actually unreasonable for that warning to be valid 12 months after the actual event occurred or the incident occurred. The Commission, interestingly, didn't have any power to do anything about that. The Commission didn't have the power under the legislation to overturn the warning. The Commission advised the employer should consider overturning the warning, but couldn't find against the employer on the basis that only one of the allegations was substantiated, and therefore it was not repeated and didn't meet the requirements of the definition.
Yeah, actually, Steph's just come in with another question here. Thanks, Steph, for joining us again. Richard, when might management action be unreasonable in this sort of situation?
That's actually a really good question. It's perhaps easier to explain when the management is unreasonable than when it is reasonable. And when it's unreasonable is, for example, in situations where someone else was treated differently for a very similar type of incident, and what we would call differential treatment. So, Ian, if you and I both behaved in a similar manner, I got a warning and you didn't, then that could be determined to be unreasonable. If, for example, a policy provided for a certain process in addressing a performance or a conduct issue, and the employer unreasonably did not follow that process, then that could be considered to be unreasonable management action. And also, as the example that we just got with the Park Beach Bowling Club, and that was if the action wasn't taken in a timely manner. So in other words, in that case, the action occurred some 12 months after the incident, and that was in part the reason that the Commission found that it was in fact unreasonable.
Great, thank you. Actually, another question has just come in, Rich, while we're going. Ellen, thanks, Ellen, for coming in. Was the warning sent 12 months after the event occurred, or was that warning 12 months ago? Oh,
no, that's perhaps I haven't explained myself properly there, Ellen. No, that warning was for an incident that occurred 12 months earlier. So the investigation process found that there'd been an incident that occurred 12 months earlier, and the employer then, or the bowling club then went on to issue that warning 12 months after the incident occurred.
Great, thank you.
Now, this just moving on to, and this absolutely shocked us here, myself and my colleagues here at the Victorian Chamber, when this decision came down in December last year. It's a full bench of the Fair Work Commission decision, so it has significant weight. And it really genuinely impacts upon any employer that uses fixed-term contracts as a method of employing staff. And we know that many employers across all sectors and regardless of size use fixed-term contracts as a method of employment for good reason. And that has historically been to provide flexibility, especially in terms of perhaps testing whether an employee is a good fit for a job before making the decision about keeping that employee on for a longer period of time, or in industries and circumstances where the nature of the work is difficult to predict, meaning an employer can't really make a decision about the ongoing need for a position, and therefore puts in place a fixed-term contract to make that determination during the period of the time of the contract. And so historically, the Commission has found that if an employer and an employee enter into a fixed term contract that has a clear start date, a clear finish date, that the employee agrees to the terms of the contract before the commencement of the employment, meaning that the employee clearly knows beforehand that the employment is of a fixed term nature and that the contract will end on a particular date, then when that contract isn't renewed, historically the Commission have determined that, and this is a rather curious type of a phrase, but the Commission has determined that that contract has expired due to the effluxion of time rather than at the initiative of the employer. And so the contract has actually ended in accordance with the terms that were agreed at the outset, and therefore the employer didn't take any active step to terminate the employment.
Okay.
So when this decision came out, it actually flipped that concept on its head, and it talked about the difference between a time-limited or an outer limit contract and a contract for a genuine specified period of time. And the difference there is that a contract for a specified period of time doesn't have any provision for the employer to terminate the contract before the end date, other than in circumstances of serious misconduct. Whereas a time-limited or an outer limit contract has the capacity for the employer to terminate the contract before its expected due date. And this slide here goes a little bit further to explain the differences between those two concepts. So if you were looking at a specific task, or you were looking at a position that was funded from tenuous funds, for example, was funded from an external source and you couldn't be certain about whether the funding would continue beyond the life of the contract, that is when we would argue that an employer is on really strong grounds to demonstrate that a fixed-term contract was for a specified period of time. And in this Navitas decision, they found that, or the full bench of the Fair Work Commission found that if a contract is for a specified period of time, it will be unlikely that it has been terminated at the initiative of the employer, and therefore it would be unlikely that an employee could pursue a claim of unfair dismissal. Now, the consequences of this Navitas decision are that when employers employ employees on fixed-term contracts that might roll over or that end and there is still a genuine need for the work to continue, then the employee in those circumstances won't be excluded from claiming that their employment has been unfairly dismissed, whereas in the past, the employee had no access to a remedy for unfair dismissal. That's a significant consequence of this decision. We think that there'll be many, many more cases of employees claiming unfair dismissal at the conclusion of fixed-term contracts.
Yeah, actually, Kate's just come in with a question on that one too, Richard, I think. When it was actually a very interesting one. When an employer does not want to renew a fixed-term contract, what should they do to actually minimise the risk of a future claim? How can they sort of minimise that risk?
Perhaps the best way to answer that is to go right back to the start and look at that last dot point on that slide and assess the nature of the employment before it even commences, so that at the outset of the employment relationship, the employer looks at whether or not a fixed-term contract is the most appropriate mode of employment, meaning if it's genuinely for ongoing work and it genuinely appears that the work will continue, that there's no funding questions, that the business is in a growth mode rather than in a downsizing mode, an employer would be well advised to consider putting in place an ongoing position or a permanent position and utilising the probation or qualifying period to make an assessment of the employee rather than putting the employee on a fixed-term contract.
I think that's really good advice. Actually, another question, just quickly race through again, Richard. I'll read out. Thanks, Darren, again. If possible, could you discuss the impact that long-term employment on multiple fixed-term contracts, i.e. 7 years or 7 actual contracts, if the funded source ends, is that employee entitled to any special consideration due to a long tenure? You got that one?
I've got that one.
I hope I got it right there, Darren.
The long tenure will certainly impact upon the rights and obligations, meaning the rights of the employee and the obligations on the employer. This is the sort of situation where an employer is at risk of an employee making an unfair dismissal claim unless they can genuinely demonstrate that the 7 annual contracts were linked to annual funding. In circumstances where the employer could demonstrate that the fixed term contract was genuinely linked to annual funding, the employer would be on pretty solid ground to argue that the contract had legitimately ended at something other than the employer's initiative. But in answer to the question, I think that the longer the employment and the more that the contract is rolled over, the higher the risk to the employer.
Yeah, thank you, Richard.
So the bulk of the message today really, I hope, is to go to the unfair dismissal legislation and perhaps provide a very quick overview about what the legislation is before looking at what we consider to be some really interesting cases and some really interesting lessons that employers can take from those real cases. The focus today is going to be on this concept of harsh, unjust or unreasonable. For those that are interested, this is addressed at section 387 of the Fair Work Act, and these are the most common types of unfair dismissal claims. An employee can claim that they've been dismissed because of a redundancy that wasn't genuine. I don't propose to look at that today. I propose that we could consider having a separate session on that particular issue. But in terms of today, the harsh, unjust or unreasonable concept has been around for a fair while now. There's a seminal case that goes back probably 20 odd years now, which determined that a dismissal can be harsh but not necessarily unjust or unreasonable. It can be unjust but not necessarily harsh or unreasonable, or it can be unreasonable but not necessarily harsh and unjust. And so the Commission look at all three of these concepts and can find on any particular one. And in preparing for this session and trying to explain in as simple terms as I possibly can what those three concepts mean, harsh really means that it goes to the penalty, invariably that the punishment doesn't fit the crime. Unjust generally means that someone else has been treated differently for a similar manner, the example that I gave earlier about differential treatment. And unreasonable would most likely go to a failure of process or the fact that the employer didn't have a valid reason. You can see there that the primary remedy for reinstatement, the primary remedy for unfair dismissal is reinstatement back to the position prior to the termination. And in many circumstances, if reinstatement is ordered, then the employer is also ordered to pay the back pay for the period between when they're reinstated and when the dismissal took effect. So that's quite significant, because if you get it really wrong, there is a genuine possibility, albeit it is quite rare, but there's a genuine possibility that you can end up back with the employee in the workplace and have to pay the difference between when they were terminated and when they were reinstated. That's the worst case. When we look at the concept of unfair dismissal, this table is really quite handy in terms of explaining at a high level what an unfair dismissal is. And there are two basic questions. One goes to substantive fairness, and that effectively means that the employer had a valid reason for the termination. And the second goes to procedural fairness. So not only does the employer have to have a valid reason, the employer has to put in place a process that is fair. Now, procedural fairness effectively goes to the concept of natural justice. And as you can see there, the concept of natural justice is such that the employee understands what's being put to them, that they have an opportunity to respond before a decision is made, and that any mitigating circumstances are taken into account. Now, the purpose of this session today is really to talk about that very last matter down there on the table, any other matters considered relevant by the Fair Work Commission. And this goes to a subsection of the Act known as 387H. And what we see more and more is that the Commission is obliged to go through all of the subsections underneath 387. And it comes to section 387H, and the wording is that the Fair Work Commission may consider any other matters that are relevant. And what we're finding is that the Commission is more and more inclined to say, well, we're happy with the reason, we're happy that the employer went through a fair process. However, nevertheless, I've got the discretion to make a finding, and we're finding that they're using this section of the Act more and more to determine in the employee's favour that there was some factor that otherwise made the termination of employment harsh, unjust or unreasonable. And I thought that the best way to explain that concept around any other matters considered to be relevant by the Fair Work Commission is to look at some real examples.
Great.
And as I said, this is something that we're very passionate about because we follow the Fair Work Commission decisions naturally, and we're just seeing a growing trend here that the Commission is choosing to use its discretion more and more. So the first example here I've got is in the mining industry in Western Australia, and the circumstances here were that we've got a situation where a technical worker was on a bus which was transporting a whole lot of other workers away from where they were residing to the actual site that they were working, to the mine. So they've all jumped on the bus. The employee in question, Mr. Solon, was talking to a few of his colleagues in about the middle of the bus, and he was heard to be talking to his colleagues about a situation of, well, I'll try and put this delicately, but he was overheard talking about a sexual encounter with an Aboriginal woman in a derogatory manner. Now, it happened that the person that overheard the conversation was sitting a few rows back in the bus and was an Aboriginal. And being out in the remote area of Western Australia, the employee that was making this remark was actually referring to local Aboriginal women. The Aboriginal man on the bus was from that area and took it that he was talking about women that may well have been part of his family. And without going into the detail, the conversation was very offensive and crude in nature. Now, what happened here is the Commission went through the process and said, yes, the employee has breached the policy. Yes, it's most certainly discriminatory in nature. Yes, it was completely inappropriate. So therefore, the employer had a very valid reason to terminate the employment. Before they took the decision to terminate the employment, they provided the employee with an opportunity to respond. The employee was represented by his union, so there's no questions there. And there was no procedural flaw in the process. And then it got to 387H and said, but however, I've got the discretion here to take into account any other relevant matters. And the Commission here said that what is relevant is that it wasn't so much what the employee said, it was the fact that it was overheard. And what the Commission found here is that if the comment hadn't been overheard, then it would have been okay. And it was unfortunate that it was overheard, but that's not the issue. What the Commission also took into account was the fact that the employee went to the Aboriginal workmate pretty much as soon as he understood that he was offended by the comment or had overheard the comment, and apologised and showed genuine remorse. And so the Commission said that because the employee had a previous good record and he apologised so quickly and in such a genuine manner, that was relevant to whether or not termination was an appropriate action, and the Commission said that it wasn't, and so therefore ordered the reinstatement of the employee. We were really surprised by this decision, and in particular a phrase where the Commission found that it wasn't so much what was said, but that it was overheard. But it is certainly a real example of the employer doing everything wrong, having a good reason, and nonetheless having the Commission overturn that reason and reinstate the employee.
That's a really good example. Thanks, Richard.
The second one's also the mining industry in Western Australia, and this is another a good example. And this goes to the question of differential treatment. So to give the base facts here, this mine is located about 1,200 kilometres north of Perth, and the nearest closest town has a population of about 500. there are about 1,500 miners at this mine, and they actually reside in the town. And because of the impact upon the town, Bechtel, the employer, has put in place policies that say you must behave out of hours as we would expect you do inside hours, because of the impact that we have upon the local community. In other words, as part of their contractual arrangements, they had to sign up to the fact that they would behave outside of work as well as inside work. And what happened was that there were two employees. They happened to be in a relationship, a male worker and a female worker, as it turns out, and they'd been celebrating a birthday. They went back to the motel that they were staying in inside this small town, and they had an argument. Apparently the argument went for 20 or 30 minutes. It was very loud in nature, and as a consequence of the argument, or after the argument, the male employee actually had a shower and either deliberately or accidentally smashed the shower. And so not only did we have a very vocal and robust argument that occurred in this motel room, we had physical damage to the property of the motel. So there were a couple of residents that complained about the argument, and the owner of the motel then went to the company and complained to the company about the behaviour of these two employees. So again, what the employer did was put in place a rigorous investigation. They stood the male worker down. They didn't stand the female worker down. And they went through a proper process, and they concluded that there was just cause to terminate the male employee, and they made that decision. The commission went through the process that was followed and said, you had a fair reason. He has acted outside the policies and code of conduct that had been agreed to, and you actually put in place a really good process. The investigation was robust. You gave the employee plenty of opportunity to respond. And so, again, if we go back a couple of slides, there was a valid reason, and the employer had put in place a proper process. But what the Commission looked at here, when it had the opportunity to use its discretion at Section 387H and take into account any other relevant matters, the Commission found that it was unjust, because Bechtel, the employer, claimed that the male employee was more at fault because he instigated the argument, he was louder, and he was responsible for the damage to the shower. And so they gave the female employee a first and final warning, whereas they terminated the employment of the male employee. And the Commission found that the difference in conduct wasn't so great as to warrant such a difference in penalty. In other words, it wasn't fair that she got a first and final warning and his employment was terminated. The Commission also found that the decision was harsh, and this is really interesting because Bechtel had a policy, or Bechtel had a number of policies, but Bechtel had a policy that included defining the concept of misconduct as opposed to serious misconduct, and the Commission looked at the policy and determined that the type of behaviour that occurred was more consistent with misconduct rather than serious misconduct, and that terminated the employment on the basis that the employee had engaged in serious misconduct, and so therefore the Commission found it to be harsh, meaning that it was more accurately characterised as misconduct as opposed to serious misconduct.
Thanks, Richard. Actually, Paul's just popped in with a question, which I'm almost afraid to ask, Paul. I don't know. Just watch yourself, please. Because Paul's saying, what is the difference between misconduct and serious misconduct, Richard? And I'm very afraid to ask that. Thanks, Paul.
At a high level, if we look at common law principles, serious misconduct is conduct of the kind that is said to go straight to the heart of the employment relationship. So going back hundreds of years to English common law, serious misconduct is a concept whereby the behaviour is such that the employee has repudiated the contract. When we look at serious misconduct, that would be in the guise of physical violence, deliberately disobeying a reasonable and lawful direction. An example would be a breach of a known drug and alcohol policy, fighting in the workplace, turning up drunk in the workplace. These are behaviours or types of conduct that are said to go to the heart of the employment relationship. Misconduct is something less. So misconduct can be pretty much any type of behaviour that is inconsistent with the obligations under the employment contract, but of not such a serious nature that warrants what we call summary dismissal. So perhaps the best way to describe the difference is serious misconduct is conduct that means that the employer can be justified in ending the employment immediately, whereas misconduct is conduct of a kind that is somewhat less, and if the employment is terminated, should be terminated with the relevant notice period or terminated with notice.
Thank you for that. Actually, Ellen's just asked a question of, going back to the first case you mentioned about the racist comments on the bus, and she's basically saying, well, would the situation have been, or no, I guess the result have been different from the Fair Work Commission had the person who had heard the comments, let me get the question right, been significantly affected with health and safety risks because of that, because he'd heard them. Had he taken time off due to stress or something, do you think that would have made a difference to the Fair Work Commission's outcome?
That's a good question. It's difficult to answer with any sort of authority, but my instinct is probably not. My instinct is that when we look at the rationale and the decision, and what we thought was a surprising comment around, it's not what was said, but it was the fact that it was overheard. I don't think the impact upon the person that overheard it would have made a difference.
Interesting.
I can't really answer that with any authority, but that's certainly my instinct. We were very surprised with this decision. The third one here I'll briefly talk about, again, is, in our view, interesting because this one goes to whether the punishment fits the crime. To give you a very brief background, this is, as the slide suggests, a garbage truck driver. The garbage truck driver was caught, as you can see, in the early hours of Sunday morning by a city inspector urinating in a laneway. Now, that goes against all of the policies that Citywide had in place. The inspector actually gave the garbage truck driver an infringement on the spot. The employee, to his credit, went back to work and said straight up, I've just been given an infringement notice for urinating in the laneway. I'm really, really sorry. It won't happen again. It's because I had a bladder infection. I'm really, really sorry. Please don't sack me. The employer had a look and, on the basis that the employee admitted the conduct, came to the conclusion that the behaviour was a significant risk to its reputation and that it was completely inconsistent with the policies that were well understood by the employee, and that therefore there was sound reason to terminate his employment. Again, the Commission found that, the action that the employee undertook provided the employer with a valid reason to terminate the employment, and that in fact the process was fair. There didn't need to be much of a process in this case because the employee went straight back to the workplace and admitted to the conduct. What the Commission found here was that the decision to terminate employment was actually harsh, and that was on the basis that, in her view at least, it didn't warrant termination because it wasn't that serious. The Commissioner took into account the employee's long-standing good record, the fact that he was so quick and open to apologise, and the impact that the decision to terminate the employment would have on the employee and his family. So this is a really good example of the discretion that the Commission has to say, well, no, I don't think it was fair that his employment was terminated under those circumstances, even though you've ticked off all the legislative requirements.
So they're human, I guess is what you're saying there, Richard.
I think the lesson there is that even though you might have good reason and you could defend the reason, and even though you've gone through a proper process, an employer is well advised to consider the previous record, the impact that it has on the employee and the employee's family, because the Commission certainly has the discretion to do that if it so chooses.
Yeah.
I've gone ahead a slide there. And this last one is another one that really surprised us here at the Victorian Chamber. This is only a few weeks ago. And this really does turn some of the previous decisions of the Fair Work Commission on its head. We don't know whether or not that the employer will appeal this decision. We're actually hopeful that they will, because one way or another it'll give more authority or clarity to what we consider to be quite a new and novel interpretation of the Fair Work Act and the unfair dismissal provisions. And just to give you a very brief overview, this employee, again, worked in a Tasmanian mine and worked on a conveyor belt. He operated buckets on a conveyor belt. Now, the conveyor belt was down for maintenance. It was really clear that the conveyor belt was down for maintenance because there were barriers and there were tags that said the line's inoperable at the moment, it's down for maintenance. The employee was told the day before that it would be down for maintenance, and he chose to drive his forklift through the barrier tape and remove the tag and start the machine on the understanding that the maintenance had finished. And he made an assumption because he saw the maintenance worker packing up his gear, and he wanted to get on with his job and process the zinc for whatever reason, and didn't check beforehand to make sure that the maintenance work had finished, and quite literally removed the safety tag. Now, when we went through the process, or when the Commission went through the process here, again, they found, yep, that's a really serious safety breach. In fact, it was so serious that there was someone on the belt at the time that he started it up, and it could have caused serious risk to one of his, serious injury to one of his colleagues. So yes, we've got a very serious breach of a known safety requirement. Yes, the employer had in place a proper process, gave the employee a proper opportunity to respond, determined that the employee knew what he was doing, and took into account his response, and nevertheless went ahead and terminated his employment. Now, the legislation provides that the employee is entitled to respond to the reasons for the proposed termination of employment before a decision is made. And the Commission here found, yep, the employee had the opportunity to respond to the reasons, but the employer didn't provide the opportunity for the employee to respond to the proposed sanction, meaning we're going to terminate your employment. Please provide submissions as to why you think that sanction is not appropriate. And the legislation doesn't require an employer to do that. So this is where we were surprised, and we see the Fair Work Commission again using its discretion at this part of the Act to take into account other matters that we say go beyond the legislation. And in this case, what the Commission did was say, well, you should have given the employee the opportunity to say, I've been with you for 37 years, I've got a good record, I've got a mortgage, I'm working in Tasmania, I'm 65 years of age, I'm working in an unskilled job, I'm never going to be able to get another job in Hobart. The decision will have a significant financial impact on my family and myself. I want you to take all of that into account before you terminate my employment. Now, the employer didn't do that. The employer took into account his response was, yep, I took off the tag, yep, I drove through the barrier, yep, I understand that I put a colleague at serious risk, but they didn't take into account those mitigating factors before they made the decision. And this is the real lesson here, and I think it's a significant lesson, is that if an employer is going to terminate the employment of an employee, that they should actually ask the employee not only to respond to the reasons for the termination, but also to respond in terms of the sanction proposed.
And Richard, what I'm getting out of this is, I think Stephen has just said as well, it's a minefield out there. The best thing is to get advice. It's because it is very confusing for the layman, and I think expert advice is very, very important.
Well, Ian, we do say that. I've got a live example of a case that I'm handling myself. It's only come across my desk in the last week, and this is it goes very much to this precise slide, because this is a situation where the employment of someone was terminated for making what was genuinely a really inappropriate comment to a customer. Now, it was made, it was owned up to. Now, the employer didn't seek our advice before going ahead and making the decision. And we would have said, well, you've got a good reason, put in place a process, and they did put in place a process. They put it to the employee, they provided the opportunity for the employee to respond. The employee admitted to the conduct. They went away before they made the decision and considered her response, and they came back and terminated her employment. Now, when the unfair dismissal application came in, and when I was caused with the responsibility of talking to the employer and getting the background, it came to my attention that this literally was a 65-year-old woman, literally, this is a national organisation, literally employed in remote New South Wales. It's a social and community health service, had been with the business for more than 20 years, and her only previous warning with respect to her conduct was many years before. Now, I'm very, very concerned that if this case went to the Fair Work Commission, that the Commission would use the discretion that it has at this part of the Act to say that the termination was harsh, and that this particular case that we're just looking at now, Brian and Nice Star Hobart, demonstrates that the employer would have been well advised to take into account the employee's age, length of service, and the remote nature of the employment before it made that decision.
Wow, that's fantastic. Thank you. Actually, another quick. Darren, hello again, Darren. These the examples and policies you've spoken about with for full-time workers. What about volunteers in that situation?
Okay, that's a really interesting question and an absolute minefield when we speak
again another minefield
when we speak about volunteers, because if a person is genuinely a volunteer, then they're not employed and therefore they're not covered by the Fair Work Act and the unfair dismissal provisions. That's the straightforward but accurate answer to that question. They're either an employee or a volunteer. If they're genuinely a volunteer, then no, these policies and processes don't apply because they're not employees.
So out the door, thanks very much. Doesn't matter whether they're 65 or 18.
Well, the volunteers still at some point in time may attempt to argue that in fact that they were incorrectly characterised as a volunteer and therefore were more properly characterised as an employee and therefore should be entitled to these policies and processes. But that's where the minefield lies as to whether they're genuinely a volunteer.
And
or
honestly, this just keeps. I mean, I know I flogged membership for VTIC, but hey, this is just telling me a complete membership is worth its weight in gold. Maybe we should be doubling the price of a complete membership of VTIC for advice like this. This is fantastic.
Well, thanks very much, Ian, for that embarrassing comment, but thank you. I'm really mindful of the time, and I did want to just talk very quickly about investigation processes and to try and leave some tips and tricks in terms of investigations. Very quickly, an informal complaint procedure is, as the slide suggests, appropriate in circumstances where the incident or the complaint is less serious in nature and may quite possibly be addressed in an informal manner. When we look at more serious incidences or more serious complaints, it's ordinarily more appropriate to take a formal process. And what we say here is that if you're intending to terminate the employment of an employee for reasons of conduct, which is quite different to reasons of performance, then the Fair Work Commission will look at what investigation process the employer undertook before it made the decision to terminate the employment. So some of the key elements of a formal approach, and I'll speak against the slide here in some respects and perhaps just to summarise more broadly. At the outset of a formal approach, we advise strongly that there is a really clear scope established. In other words, what is it exactly that is being investigated? And to make sure that that scope is defined just to that incident or just to the employee concerned, and not allow the scope to broaden out and muddy the waters. So a really defined scope. This investigation is looking into an alleged incident that occurred on the 21st of February at 10:30 a.m. in the kitchen at the Victorian Chamber. Really narrow the scope so that it can't broaden out and take into account irrelevant or extraneous matters.
Gotcha.
A key feature of a formal process is that an investigator interviews a complainant and interviews witnesses and then puts specific allegations to a respondent to the complaint. An investigator analyses this on the terms of whether or not these occurred. In other words, did that incident occur as alleged on the balance of probabilities, yes or no? And then those outcomes of the findings against the allegations are communicated, but the recommendation that we make is that the participants to the investigation process aren't privy to the entire report, that they just get the high-level outcomes of the investigation process.
A couple of quick questions just come through. Firstly, just a reminder to everyone, this webinar is being taped and it will be placed on the VTIC YouTube site within the next 24 to 36 hours or so. So you can't ask questions, but it'll be on that. So yeah, it'll be on that for your own viewing, listening and reading pleasure. And Richard, one question from another Paul. Can you define the role of a support person in any investigation or complaint?
Yep, I think that the clearest definition of a support person is exactly that the person is there in support, that the person is not there to advocate on the part of the employee, that the support person is there to witness the process rather than the substance. So okay. What we do or what we advise in terms of support persons is to explain at the outset of a process the role. We actually have protocols that we ask support persons to agree to beforehand, which effectively commit the support person to not interrupting, to not advocating on the employee's behalf, to being witness to the process, and therefore, if the employee concerned was visibly stressed or upset or wanted a break, that the support person can ask for a break and go outside and separately talk to the employee. But the employee represents themselves. It's an interesting question because a union will often argue that they have a right to represent, and in some cases they do. And so with unions, they will very, very rarely acknowledge that they're in support of an employee, that they'll more likely say that, no, we're here as a representative, and you'll have perhaps a more difficult argument on your hands. What we'd also say in terms of support persons is that it really shouldn't be someone who is privy to the complaint. In other words, if it's a really close workmate who has seen what's going on or might be impacted upon by the issue in question, we advise that employee is better placed not to be a support person, that the employee seeks to choose someone else.
Yeah. Thanks, Richard. Just a quick one. I'll have to skip through some of the questions. Questions will be answered individually later on if we haven't got to them over the course of the webinar. But Maria's asked a good one. If an investigation points to a much bigger issue, what happens to the defined scope?
Yeah, Maria.
It all grows. Yeah.
Well, that's another really good question, and I think the quick and simple answer to that is that you'd have a separate investigation into that process. So in my view, once you've put specific allegations to an employee, you live and die by those allegations, meaning those allegations have a life of their own, and you progress those allegations through to a conclusion. If in that process the investigator, and it often happens, raises broader issues, then we say that the employer is well advised to separately look at those issues. What often happens, Maria, in these circumstances is that when allegations are put to a respondent, that we see a counter complaint from that respondent, and in those circumstances we consider that there are separate allegations put to separate people as a separate process.
Great, thank you, Richard.
Now, I really am just about at the end here, so I'm very mindful of the time, and I appreciate everyone's patience in hanging on for the full hour. It's terrific. I'm very grateful for that. But just to leave a couple of tips, and I think that this in part goes to the questions that Maria's put, but we say that to be able to defend an investigation process, in other words, if we go back to this section of the Act where the Commission has the discretion, it will invariably look at an investigation process and whether or not that was fair. Don't do it half-hearted. If a respondent to an investigation process says, look, Tom saw this and Jenny saw this, I really want you to go away and talk to Tom and Jenny, then you should go and talk to Tom and Jenny. Now, that does make the investigation process broader, but an employer is well advised to obtain all the relevant information and then objectively review all of that information before making findings. We see, and this happens more and more, and if we had more time and a different day, I could bring up other examples of this when the Fair Work Commissioner has had a look and said, well, hang on, you were judge and jury here. You investigated the process. You reached some conclusions about whether or not the behaviour occurred, and then you went ahead and made the decision. We advise that the decision maker is removed from the investigation process. So the investigator presents to the decision maker findings of fact that the decision maker then has the choice of either accepting or not. When the matters are really serious, we suggest that employers consider suspending employees. That can be very painful for an employer because most often employees are suspended with pay, and investigations can often take some time. Now, when we do investigations, we do our very best to make sure that they're undertaken in a timely manner. That's a primary objective. But an investigation, once it's commenced, even though you may have a defined scope, you don't really know how people are going to respond. What we often see is the respondent to a complaint may go off sick, and that will invariably blow out the timeframes. And I guess the key message, and what I'm hoping people take away today, is that in making any decision prior to terminating an employee's employment, please be very mindful of the discretion that the Fair Work Commission has. In other words, you've got a valid reason, you've followed a proper process, but nevertheless, the Commission might find that a termination was harsh, unjust, or unreasonable.
As you pointed out in those examples before. And
in those circumstances, the worst possible case is the employee gets their job back. So what we'd always say is that if you're unsure, take advice before making a decision, because any decision can ultimately be very costly, and you can't undo a process once it's done. Look carefully at your policies and make sure that you follow your policies if you have some. If you don't have some, consider putting policies in place, because policies help provide a defence that everyone's treated in the same way. So that if you follow a policy as it applies, it's very difficult for an employee to argue that they've been treated in a different manner than they would have otherwise been. And just to finish up on, as Ian's alluded to, the Victorian Chamber have a workplace relations helpline for its members, including VTIC members, and if problems are particularly problematic, for example, if employers need to undertake workplace investigations, then we've got expert consultants that can assist in those types of matters. But otherwise, I think I've finished pretty much on the hour, and I think we've
covered off most of the questions.
I think we covered off most of the questions, looking at them on the screen.
So, and Richard, I mean, on behalf of everyone, who's been listening, everyone at VTIC and a website, thank you very much. I've personally found it a really, really good last 50 minutes or so. Really interesting. The quality of the questions has been fantastic, and I think people who have stayed on for the entire duration, they've actually really learned a heck of a lot. So, thank you so much for your time. As you know, folks, these webinars we don't necessarily run them for our benefit, we run them for your benefit. It's all about member engagement, making sure you're happy with your VTIC membership and our partnership with the Victorian Chamber. So in that line, our next webinar is PR for Tourism Businesses, Telling Your Stories, being run by proud VTIC member Chatterbox Marketing, and that's on the 21st of March. You know how to register, the normal procedure. Jump onto the vtic.com.au webpage and through to our events, lots of events coming up. But also, hey, while we're on future webinars, please tell us what you would like to learn from these webinars. We do these webinars for you. We've had a few hints in the past, and that was one of the reasons why we asked Richard to come along today and give an hour of his time to talk to us about workplace relations. It's because you told us what you'd like to learn about. So any future hints or tips or future webinar topics, please drop me a line. Ian McDougall at VTIC. Lots of other events coming up in VTIC land next Wednesday. The 28th of Feb, the VTIC and Tourism Australia Visitor Economy Forum. It's an all-day job at the Melbourne Convention Exhibition Centre. It promises to be a sensational day. Here from VTIC's brand new Chief Executive, Felicia Mariani, only started with us about 6 weeks ago, and what we're doing in the year ahead. Hear from Pete Bingaman, the Chief Executive of Visit Victoria, Danielle Green, the Parliamentary Secretary for Tourism in the Victorian Government, and the afternoon is all about Tourism Australia, what they are doing internationally to help put people in your beds and fill up your buses and your tour groups and all that sort of stuff. So hear all that about it, and I'm sure that the new potential Croc Dundee movie slash Super Bowl advertisement we're going to mention as well. Otherwise, please do make sure you jump onto that website listed down the bottom at our events page. The next Mixer series, first Wednesday of every month. The webinars, third Wednesday of every month. And of course, a big one coming up, 30-31 July, the Victorian Tourism Conference at the RACV Cape Shank Resort. Compelling speakers, compelling workshops. Registrations will be opening soon, but please diarise those dates and make sure you are there. I think that's almost it, except for a final big thank you to Richard Williams. There's Richard's details there. Happy to accept emails and calls, whatever. The VTIC number there is there. The web firm number is there. Again, once again, from all of us at VTIC, a huge thank you to Reese and all the guys and girls at Web Firm, our digital marketing partner, someone that we're really, really proud to work with, but especially to Richard for this morning's hour. Fantastic, mate. Thank you so much. Very, very valuable. And this webinar will be on our YouTube site very soon. Jump onto the vtic.com.au website, and on the very top of that, you'll find a little YouTube link. So, as we do traditionally with our normal sign-off, VTIC, improving the world, one webinar at a time. Thank you very much.